So we're going to split this into two parts. The first part, I will give each side a 5-minute oral argument to determine whether or not we should allow in the evidence that was submitted prior to the last meeting. And then the commissioners will break into executive session, let you know what that ruling is. Then we will allow each side 10 minutes of oral argument on the actual petition for reconsideration. The commissioners will break into executive session again, and then we will let you know that ruling. So if you're ready to begin, we'll start with Mr. Huguenin, and you will have 5 minutes starting now.
Yes, thank you, Madam Commissioner. It's good to see you all again. I was not prepared on this initial motion, but I think I can adequately address this. With respect to the motion for reconsideration, Exhibits 1 through 6 are all matters of public record, and that's just to identify to the court and present as part of the record the issues that I raised post the pleadings closing for the initial petition for review. They were brought up in the context of oral argument, but a lot of the events that transpired only occurred after the pleadings had closed. And so that is to further establish the arguments I made orally regarding the disposition, for example, of the administrative charges related to Hector Enriquez. Importantly, there is, as Exhibit 5, a pre-hearing conference order in this particular touch matter that I wanted to draw the Commission's attention to as it relates to the conversation that we're having here today, specifically an oral argument. My recollection of Mr. Vanderbreek's position was that prior counsel did not conduct any discovery. However, based on my review of the pre-hearing conference order, no discovery was actually permitted in the touch matter. And I think that's important because there is now the additional exhibits that were provided on reply. And I want to address that in the context of a CR 59 consideration, and that's specifically with newly discovered evidence. The caveat to newly discovered evidence is that it would have had not been discoverable by reasonable efforts of the party prior to the CR 59 motion. And Ms. Touch asserts that that's the case here for a variety of reasons. First, with respect to how I obtained this to a public records request that I actually submitted back on, I believe, on or around January 24, 2022. It took 1.5 years for the Gambling Commission to produce this, and even then when it was produced, they tried to conceal critical components that I brought to the Commission's attention by way of the reply material. Additionally, it would have arguably been exempted under the exemption for an active investigation. And finally, because no discovery period was provided, Ms. Touch would not have been able to, even through prior counsel, make an interrogatory or request for production for that purpose. So for that reason, the text messages that show the collaboration, the conspiring between Agent Ronnie Cooper and two of the key witnesses, Mr. Martin and Mr. Stroud, in this matter, asking for non-direct help that then led to a couple months later, administrative charges being filed against one of Ms. Touch's key witnesses that then Doug Vanderbreek utilized to discredit Mr. Enriquez and then also intimidate Mr. Enriquez should be admitted into the record so that way we can preserve this issue for appeal should the Commission deny Ms. Touch's motion for reconsideration. Thank you.
Thank you. Mr. Vanderbreek?
Thank you, Commissioners. Mr. Huguenin, in response to Mr. Huguenin's claim that this case did not allow discovery, he is wrong. Mrs. Touch's attorneys had 2 opportunities to request discovery. That's what is in the record. At the initial pre-hearing conference on November 19th, 2021, the attorneys for the parties had an opportunity to request discovery schedule be built into the case schedule. Mrs. Touch's attorney did not request discovery. This is from the record. The administrative law judge questioned Mrs. Touch's attorney. Anything else that we need to put into your case schedule? Mrs. Touch's attorney's response was, no, Your Honor, that's it for the case schedule. Subsequently, Mrs. Touch's attorney had a second opportunity to request discovery for this case schedule, but did not do so. That occurred on February 9th, 2021 at a status conference in which Ms. Touch requested a continuance of the hearing and more time to file a witness and exhibit list. At that status conference, and it's what's in the record, the judge asked Mrs. Touch's attorney, I quote, so I want to confirm, Mr. Guadagno, you're asking me for two things, a rescheduled hearing date to give you time to prepare, and a rescheduled submission date for appellant witnesses, witness and exhibit list and documents for basically the same reason. Are you asking for anything else besides those? Answer, correct. Question, are you asking for anything else besides those two things? Answer, I'm asking for only those reasons, Your Honor, and for those two purposes. So the parties had an opportunity. Mrs. Touch had more than one opportunity to request that a discovery schedule be built into the case schedule. She did not. Now, regarding the screenshots of text messages that were attached to Mrs. Touch's reply to the staff's response to the motion for reconsideration. It's important for all the reasons we argued in our petition for review when Mrs. Touch tried to introduce exhibits that were not on the record. The commission's review, in this case, is limited to the record that was created at the evidentiary hearing. Okay, and just like the previous decision that the exhibits that were not part of the record should not be considered, so too should these screenshots of text messages not be considered. They're simply not part of the record. Furthermore, it's very important to consider the dates that were relevant in this case to show that those text messages and screenshots had no relevance to the dispositive fact that was on trial here, and that dispositive factual issue was whether the overpayments occurred as alleged. Okay. Now, the overpayments occurred on August 2nd, 2021. Commission staff opened the investigation on August 10th, 2021. Staff's investigation was completed on September 28th, 2021. The notice of administrative charges were issued on October 19th, 2021. Those screenshots of the text messages are communications between an agent who had no involvement whatsoever into the investigation of the overpayments at issue in this case. The agent in those communications of the screenshots of the text messages was conducting an undercover criminal investigation involving various players and other licensees, not Mrs. Touch or Mrs. Chan. Those screenshots of text messages simply have no relevance to the factual issue here. That concludes my response unless there are questions. Thank you.
And commissioners, I do request just a brief minute to provide a reply to what was just stated there by Doug Vanderbrake.
You have 1 minute and 18 seconds left of your 5 minutes.
Thank you very much, Madam Commissioner. First, Mr. Vanderbrake has not entered into any sort of written pleading the alleged statements that he asserts were made in these evidentiary hearings, so that needs to be stricken as part of his argument. Second, we are here on a CR 59 motion for reconsideration, and it specifically envisions newly discovered evidence. What we are here arguing is not the allegations that were made against Ms. Touch. That's not what we're here for. We're here presenting this evidence to establish the bases under CR 59. CR 59A2 addresses misconduct of the prevailing party, and we've addressed that on pleadings. I'll address that in oral argument as well. Importantly, CR 59A4 addresses newly discovered evidence. even taking what Mr. Vanderbeek says as being true about no discovery period being requested, perhaps the attorney didn't realize he had to. The reality is, as Doug Vanderbeek just indicated, there was an active investigation going on. Even had she requested it, it would have been exempted from any sort of production, which is why it took 1.5 years for me to get it through a public records request.
It's your time, sir.
Okay, and I appreciate your time and consideration on this matter.
Thank you. The commissioners will now break to executive session. Okay, good morning. We are back, and just a quick clarification that we were in closed session for our deliberations and not executive session. Okay, and back to the evidence. We have decided that we are not going to allow the evidence that was presented at the last hearing. We're going to move forward on the existing administrative case for the motion for reconsideration. So we will start again with Mr. Huguenin. You will have, or let's make sure Commissioner Lawson and Commissioner Ibsen are back. Sorry.
Madam Commissioner, am I able to understand the basis for the denial?
You'll receive an order prepared by staff at a later time.
All right.
And I see Vanderbeek. Are you here? Just want to make sure you're back.
Yes, I am.
Okay, perfect. Okay, so we will go ahead and start with each side. We'll have 10 minutes. We'll start with Mr. Huguenin on the motion for reconsideration.
Thank you, Madam Commissioner. I respectfully request a reservation of time of 3 minutes for rebuttal. After a hearing on the written materials related to Ms. Touch's petition for review, this commission decided to confirm as a final order the initial order from the Office of Administrative Hearings in this matter. However, after the pleadings were closed on Ms. Touch's petition for review, there were certain events that occurred and certain additional pieces of evidence that were discovered which pertain to the arguments made by Ms. Touch in her petition for review. Ms. Touch asserts that this additional information and evidence warrants reconsideration of this commission's decision from April 13th, 2023. CR 59 provides multiple bases for this reconsideration due to certain acts that have been specifically laid out and evidenced on motion and reply. Ms. Touch will rely on these pleadings to provide greater detail. That said, the general takeaway for consideration by this commission is that its staff and Attorney General Doug Vanderbeek engaged in unlawful acts to intimidate and tamper with one of Ms. Touch's key witnesses, Hector Enriquez, in an effort to curtail her defense and in furtherance of a conspiracy to harm Mr. Enriquez and those with any perceived loyalty to him. We now have direct evidence, which I understand you guys have stricken, that has occurred by way of the critical text messages between Steve Martin and Special Agent Ronald Cooper. These messages were only produced as a 10th installment to a public records request that was submitted to the WSGC back on January 26, 2022. Even then, the original 10th installment production on or around June 7, 2023 sought to conceal the substantive portions of these communications through omission and unlawful redaction. I then had to spend the next month to obtain the actual records, which only occurred in the middle of July and just about a week before the last hearing in this matter. This incident, as you likely know, I also represent Corporate Recoveries Incorporated and certain civil actions being adjudicated in King County Superior Court. This incident between Ms. Touch and Sofa Falchan is a central event to those cases and part of the conspiracy I previously mentioned. At the time of filing, the WSGC's role in this conspiracy was not known, and I should specify the WSGC staff's role in this conspiracy was not known. Now we have direct evidence, which this commission has sought to turn a blind eye to, confirming that as far back as 2021, Special Agent Cooper was actively involved in efforts to get rid of Hector Enriquez and his team, including Ms. Touch, in coordination with the very same witnesses that are being sued that the WSGC staff has relied on in presenting its case-in-chief. To wit are Stephen Martin, Yinzin Jane Wang, and Richard Stroud. This effort extended into last year when Mr. Martin then requested non-direct help from the WSGC and Agent Cooper, which again, this commission has sought to turn a blind eye to, that resulted in notice of administrative charges being brought against Mr. Enriquez mere days before they knew Mr. Enriquez would be testifying in Ms. Touch's matter. Then Doug Vanderbrake goes so far as to question Mr. Enriquez about those very charges, which were filed 6 days before this testimony. And this is after Doug Vanderbrake had Agent Maxwell come to the hearing specifically to be present while Mr. Enriquez was testifying on behalf of Ms. Touch. And it was so disruptive that the administrative law judge ultimately had to ask Agent Maxwell to leave. These are inappropriate acts of intimidation. The reality is, in this case, the WSGC staff failed to prove any of the volitional acts against Ms. Touch. Regardless of what Doug states about a former counsel not asking for a discovery period, the reality is no discovery occurred in this matter. Yet they're hinging this on her asserted character and fitness, which is exactly what Hector Enriquez would have testified to had he not been essentially shocked with fear to have first Agent Maxwell appear at a hearing that he had no business being in, to then have Doug Vanderbrake inquire about the Gambling Commission going after his license, which Mr. Enriquez did not even know about at the October 11th hearing. Then for Mr. Enriquez to be served with those very administrative charges mere days later had a chilling effect. And frankly, it was done because Doug Vanderbrake, I think, knew he was going to lose on the other aspects of this case with respect to the volitional acts of theft and cheating that were asserted against Ms. Touch. This is a sham. The reality is Ms. Touch deserves a fair day in court. She deserves to be able to have meaningful discovery. She deserves to not have an opposing party that has way more power, way more money, way more resources to be able to pursue this, to take essentially what we assert are illegal acts against her in order to curtail her ability to provide any sort of meaningful defense. I want to go over the timing that Doug brought up in the last motion. The timing of the text messages as it relates to the hearing is not what's before this court. The timing of the text messages as it relates to the actions taken against Mr. Enriquez, actions that then resulted in questions to chill Mr. Enriquez's testimony on the stand, is what is before it. And we're talking about a 2-month difference here. The reality is that occurred. At no point has Doug Vanderbrake denied that Agent Maxwell appeared and was asked to leave. At no point has Doug Vanderbrake denied that he questioned Mr. Enriquez on these very charges. And the reality is Mr. Enriquez, prior to that October 11th hearing, had another day scheduled, or excuse me, after the October 11th hearing, had another day scheduled to come and testify. And because of the culmination of these events, he was scared to do so for fear of his own livelihood, for fear of being attacked. And frankly, as the charges of Mr. Enriquez are concerned, we provided a absolute thorough review on that, showing that there was actually quite literally made up false stuff in those charges. We submitted discovery on those made up false charges. And wouldn't you know, the Gambling Commission staff refused to respond to the discovery. They continued to delay and delay. And then after the pleadings were closed on the initial petition for review, the Gambling Commission staff dismissed the charges against Mr. Enriquez. No explanation whatsoever, but they did it.
Extra 7 minutes if you wanted
Thank
to.
you. I'll reserve the other 3. Actually, no, I'll reserve 2, and I'm going to go 1 minute more, please. At the end of the day, we're here on CR 59. CR 59A2, A4, A9 provide more than enough reason for this commission to do the right thing here and actually give Ms. Touch a fair trial. There's been misconduct of the prevailing party. There's been newly discovered evidence which would not have been discoverable by any reasonable efforts of Ms. Touch, even if she had a discovery period, and substantial justice has not been done. She deserves her fair day in court. She has not been found guilty of any of the volitional acts, and all she wants to do is show that she is suitable with character and fitness to be continued for licensure and her chosen career. Thank you.
Thank you. You will have 2 minutes and 15 seconds for rebuttal. Mr. Vandenbrink, you can now begin your 10 minutes.
Thank you. This is not a Public Records Act case. What we heard from Mr. Huguenin is speculation, conjecture, and personal attacks. We did not hear citations to the evidentiary record and what the trier of fact found and concluded after 9 days of hearing. We've heard all about Mr. Enriquez. This case is not about Mr. Enriquez. As to Mr. Enriquez, it's important for the commission to hear the facts that are in the record. First off, during the trial, we're hearing it's an adversarial system. Mr. Enriquez did testify. The commission staff's counsel, me, never had an opportunity to cross-examine him on the record because he repeatedly refused to appear. These are the facts. He testified on July 27th. That ended up being one of the 2 days that the Office of Administrative Hearings lost the recording of the hearing. The administrative law judge then ended up scheduling 4 more days to allow Mrs. Touch to present her case, specifically for Mr. Enriquez to reappear to testify. They set up September 16th and 28th. On September 16th, Mr. Enriquez did not appear. Mrs. Touch's attorney informed the judge that he would appear on September 28th. On September 28th, Mr. Enriquez did not appear. Mrs. Touch's attorney informed the judge that October 11th works better for Mr. Enriquez, and then Mr. Enriquez told him that day he is available. On October 11th, Mr. Enriquez did appear to testify for Mrs. Touch. He testified from 11:09 a.m. to approximately 1:03 p.m., then told the judge that he had to leave. The judge then set up yet another day for Mr. Enriquez to testify and to confirm that October 24th he would appear. He failed to appear. This effectively prevented staff counsel from cross-examining Mr. Enriquez. Those are the facts. That's what's in the record. The other fact to keep in mind here is that the dispositive issue of fact in this case is whether the overpayments occurred. The judge presiding over the hearing had the opportunity to hear from each side's witnesses and to consider the exhibits. Mrs. Touch's attorneys never filed any exhibits. That's what the record shows. What it shows, the judge heard testimony from a dealer next to the table where the game of Baccarat was being played. She reported suspicious activity to a supervisor. She thought she saw some overpayments. Now, when the shift or floor supervisor at the casino, who wasn't there at the time, arrived later that evening, Mrs. Stevens, who Mr. Huguenin also represents, Mrs. Stevens, when learning of the report, went to the surveillance room and along with Mr. Stroud, the surveillance manager, observed a portion of the video. And Mrs. Stevens concluded that, at least for the part of the video she reviewed, the overpayments occurred. She documented that then in an email message that went to the casino general manager, Mr. Enriquez, and to the chief operating officer, Mr. McCarthy. So Mrs. Stevens, now this is in the record, okay? This is Exhibit 6 at the evidentiary hearing. It shows this email correspondence from Tiffany Stevens concluding the overpayments occurred. The trier of fact, which was the administrative law judge here, also heard from the on-site surveillance manager, Richard Stroud, about his review of the video surveillance footage. He also heard from an off-site regional surveillance manager for the casino, who also testified that the 14 overpayments occurred. And the trier of fact heard from Special Agent Jess Losey, who was the only agent involved in this investigation, and heard out Mr. Losey testified that in his review, he observed at least 12 overpayments occur instead of 14. So all told, in the record, you have 3 people who testified about what the video captured. All right. And the judge, making credibility findings and hearing that evidence and considering the exhibits, reasonably concluded, the only reasonable inferences from this is that the overpayments did occur as alleged. Okay. Those are the facts. Finally, I want to point out here, The underlying theme here is that Mrs. Touch poses a threat to the effective regulation of gambling, and that's a basis for revoking her license. Now, this is information that's in the record, okay? She has prior administrative history. In May of 2013, she received a notice of violation for underreporting her tip income to her employer. In July of 2018, she received a notice of infraction for failing to follow Baccarat game rules. In July of 2020, she received a notice of violation again and fine for again failing to follow Baccarat game rules. In June of 2020, she received a verbal warning for loaning money to a player. Now, licensees are prohibited from providing credit, gifts, or loans to players. Now, subsequent to the administrative charges in this case, Mrs. Touch and then Mrs. Chan, her friend who was a dealer, they were discharged from employment at the Iron Horse Casino for suspicious behavior regarding Baccarat games. These are facts that are in the record, okay, and it demonstrates that Mrs. Touch is not qualified for licensure. She did not meet her burden to show that she remains qualified for licensure, and for those reasons, staff respectfully request that the commission affirm its final order denying the petition for review, which did affirm the administrative law judge's initial order. Thank you.
Thank you. All right, Mr. Huguenin, you have 2 minutes and 15 seconds.
Thank you. First of all, I think it's kind of ironic that that Mr. Vanderbrake would bring up the statement of Ms. Stevens, because he's had the benefit of now deposing Mr. Enriquez on these very issues, and some very serious disparities existed in that statement from Ms. Stevens. And what Mr. Vanderbrake will find out when we depose Ms. Stevens in the sister case is that, in fact, she was forced to write that statement under duress, and that certain telltale signs of that statement have already been noted to Doug, but he chooses to rely on that. Nevertheless, the other issues that he raised about alleged past behavior, that wasn't adjudicated in this matter. You know, he brings up the notice of infraction regarding tips and verbal warnings. Those weren't adjudicated with any sort of you know, hearing or discovery. What the reality is that at the end of the day, Ms. Touch had a legal right to be able to bring a fair defense to this matter. At the end of the day, even now with this rebuttal, Mr. Vanderbrake has not denied that he used the administrative charges to question Hector Enriquez on. At the end of the day, the reality is those charges were brought up mere days before the October 11th hearing, and I'll mind you, just a couple of months after the text messages that you seek to strike. And I just want to tell this commission point blank, the truth is going to come out in this matter. The commission can continue to turn a blind eye, or the commission can do the right thing and give Ms. Touch a fair hearing. But it will come out, and it's going to happen either in this administrative hearings or it's going to happen through future litigation. So the choice is your guys' as far as I'm concerned. All I'm doing right now is trying to establish a record, but I feel like Ms. Touch is not getting a fair shake in these proceedings, and you guys are willfully ignoring evidence about certain acts that your agents engaged in inappropriately to try to further unbalance the scales as it relates to a licensee going against the commission when the commission is trying to take away her livelihood. So again, the choice is yours. Thanks.
Okay, we will again go into a closed session for our deliberations, and we will be back shortly. Okay, we are back. Let me just make sure we have Commissioner Lawson and Commissioner Ibsen. Are you here, Commissioner Ibsen? Okay, see them both here. So thank you both for your arguments. At this time, we are going to deny the motion for reconsideration and affirm the final order. So you will receive an order from the commission probably sometime early next week.